Hello, everyone. Welcome to another webinar with the CISW and the CWLC. We're so happy that you've joined us today in our continuing education programming. This webinar today is a very important one, and we are so excited that we've been joined by experts from the University of Alberta who are going to help us really decipher what's going on with Bill C-92. So if you're not aware, that's why we're here. We're here to help everyone understand. Bill C-92 is an act respecting First Nations, Inuit, Métis, and Métis children and youth and families. So today we're going to be joined by two really fantastic webinar presenters who are going to dive into what that means for social work and child welfare practices. So before I get into our incredible webinar presenters and this presentation, I just want to go over a couple little housekeeping notes. So some of our people joining us today are new to this webinar platform, so welcome. Just want to give you a quick lowdown. This webinar platform is completely customizable. So you'll see that your screen, you can move, you can change, you can make us bigger, you can make us smaller, you can make the slides bigger, however you want to do it. Take some time and really make it the best experience for yourself by navigating what you're really looking for out of this presentation. Second is that there is a box for questions and comments. I would really encourage you to type your questions as they come in. We plan to have about 10 minutes at the end for some questions and answers. All of your questions that you submit are completely anonymous unless you would like for us to share it with the group. So just type them as they come to mind, and then at the end we'll try and answer all the questions that you have, although I anticipate we're going to have quite a few, which is exciting. The second thing is that if you want a certificate of attendance, please just click the little yellow button. I think you have to spend about 40 minutes with us before you get that certificate of attendance, which shouldn't be a problem, but just get that at the end. And then note that we will have a live on-demand version that will come out approximately 24 hours after, once the MP4 has converted. So without further ado, I am going to give a quick little synopsis of what this webinar aims to highlight, and then present our webinar presenters. So Bill C-92 is an act respecting First Nations, Inuit, and Métis children, youth, and families, and it is the first federal legislation on the subject of Indigenous child and family services. The act is the first statute to recognize the inherent Indigenous jurisdiction over child and family services as an Aboriginal S-35 right in Canada. In addition, as called for in the Truth and Reconciliation Commission's final report, the statute establishes national minimal standards for child and family service delivery for all Indigenous children and families. This includes First Nations, non-status, Métis, and Inuit children living on or off reserve. So this law has come into force January 1st, but we haven't had a ton of information on what it means for social workers and social service providers. So that's what we are going to get at today. Our two webinar presenters, we are lucky to have Hadley Friedland and Corin Lightning Earl. So Corin Lightning Earl is a Cree from Sun Cree Nation. She is a lawyer with, am I saying it right? Wahkohtowin? Wahkohtowin, so no. There we go. Law and Governance Lodge. She is the vice president. Oh, goodness. Vice president of Kashokoit.
Kashokoil.
Kashoko. I'm going to leave that for you. Child Wellness Society and a board member of the First Nations Caring Society. She's an acting commissioner for Alberta Utilities Commission, and she was the Indigenous Initiatives Liaison at the Law Society of Alberta. She was also a president of the Indigenous Bar Association for 6 years. Dr. Hadley Friedland is an assistant professor at the University of Alberta Faculty of Law. Hadley has co-led the Wahkohtowin, oh goodness, Indigenous Law and Governance Lodge, a dedicated interdisciplinary unit that upholds Indigenous law and governance through community-led research and education. She was the first research director of the University of Victoria's Indigenous Law Research Unit and has worked extensively with Indigenous communities across Canada to identify and revitalize Indigenous laws. So I'm going to stop talking now, hopefully, and pass it over to our amazing webinar presenters. However, quickly before we do that, I want to get a bit of an idea of what field of social work and or academia everyone is in here. So quickly, I'm going to press to the poll. Just take a couple seconds here and go through what best describes your day-to-day practice. You can submit it, and then we'll take a quick look at the results, and then we'll pass it over to our webinar presenters. Alrighty. I'm hoping this is enough time. Great. So we're seeing lots of child welfare, some private practice. We have some students, those from academia, other. Please feel free to type in the question box what other entails. I know that it's so hard to cover the whole profession, so please let us know what field you are in. So with that, I'm going to pass it over to our webinar presenters. Thank you so much. We're so excited for this presentation, and thank you.
Good morning, everyone, or good afternoon, depending on where you are. Thank you all for joining us today. We're here talking to you via webcam from Treaty 6 territory in Alberta. So we just like to talk a little bit what we're going to talk about. So we've gone over what the bill is and the name of the bill, and yes, it's the first statute to recognize inherent jurisdiction over child and family services as an Aboriginal Section 35 right. It does enable national minimal standards, which is what we're going to talk a little bit more on, about jurisdiction and the minimal standards for child and family services. It applies to First Nation. That includes status and non-status. So Métis and Inuit children living on or off reserve. And the act is already in force. It was enforced when you woke up to celebrate New Year's Day. And it's been happening all across Canada. And the national standards also apply in all provinces as of that date. So the national standards have been effective since then. Noted that Quebec has a reference question about its constitutionality. It's appealing the legislation, but that doesn't change the course of action. So until the court finds it invalid, the law does apply across Canada. So we'll get to that bridge and cross it later, or not cross it at all.
So a lot of people talk about Bill C-92 or this act, and they feel scared and they feel like they know nothing about it. And so we want to acknowledge that this is definitely a change. It requires changes on the ground and in courtrooms and decision-making circles. And there is uncertainty here. But just starting to acknowledge that this is a much needed change. It's a response to the TRC calls to action. The first 5 calls to actions were about child welfare. It's a response to Indigenous advocacy and activism for decades here of Indigenous people saying something needs to change so we have better outcomes for Indigenous children and families. And it's in response to cases like the Caring Society case and like Brown in Canada, which is known as the 60 Scoop case, where you have that uncontroverted evidence across Canada that great harm was done for placements that at the time many people thought was the best thing for Indigenous children. So we know, we've heard the former minister talk about Indigenous child welfare being a humanitarian crisis. The human costs of the status quo are really unconscionable. A change is needed here. It's the first federal legislation in this area, and it's the first official government recognition of a Section 35 Aboriginal right. That's a constitutional right to jurisdiction over child and family services.
So a lot of time when legislation comes out or legislation changes, especially regarding Indigenous peoples, there's usually some sort of guidelines, some sort of practice guidelines, some sort of some sort of documentation besides the legislation itself to help people implement it. But in this case, there's no regulations, there's no policies, there's no practice guides yet. There's been information sheets circulated from Indigenous Affairs, and there's been information sheets created by AFN with their legal counsel. Some lawyers have given some commentary on their websites, but there's been nothing as of yet. And so we thought we would fill this void as part of our work here at Wahkohtowin Lodge, and because we both are very passionate in this field. There's been no court's interpretation of this legislation yet. We've been listening to things across Canada, hearing different challenges that have been happening. So we're more than happy to, if you have successes with this or you're having challenges, to our emails on the back. We're always interested to learn how this legislation is playing out in Canada. Provincial and federal statutes both apply. So because Indigenous people can create their own laws, there's the potential that there could also be multiple Indigenous laws created within a year. So like in the province of Alberta, we could have upwards up to, if every nation were to create a law, we could have upwards up to 60 laws, maybe more than that, depending on how many laws were implemented. So there's provincial, the federal, and then there are Indigenous laws that apply. If the Indigenous communities decide to create their own child welfare law. And we'll talk a little bit more about the fun stuff a little bit in a bit.
So there's three main purposes for this law. And one of the ways, this is actually not a big law. I'm sure nobody loves to read legislation, but if you go and look, there's something called a preamble. And if you read the preamble of this law, you can see a lot of the background of what was leading up to it. But there's also a specific purpose section. And one of the main purposes of this is to recognize Indigenous people's inherent right to jurisdiction, and that's authority over their own child and family services. This is the first time in Canadian history to have this recognition come from a government, and that's a big step. What does this mean? We'll talk about this a little bit later, the process for this, but within a year, some Indigenous groups may have their own legislation. And where that legislation or statute is different from the provincial statute right now, it will prevail over the provincial legislation. So now what does that mean? It means a lot of work goes into drafting legislation that works for communities. This isn't a one-day, one-month endeavor. It takes a lot of time to create a law that makes sense. Coordination is going to have to be worked out with provinces and agencies. And there may be unique service standards for children from different Indigenous communities that as a social worker, as an agency, you'll need to be aware of in order to comply with the applicable laws.
So the other part, main part of this law is the national standards. And so we think of national standards like as a main floor. It's like the main floor of child welfare and how we're providing services in Canada. And so they want all provinces to be on that main floor. As of January 1st, they all had to commit with these national standards that are in the law, and we'll kind of go through them a little bit. But not all provinces currently were on that main floor. Some might have been on the first or second floor. Others might have been in the basement or the sub-basement or the parking garage, who knows. But basically it was so that everybody was on the same level moving forward with child welfare in Canada. So it was basically for all Indigenous children. So all BFNAs, agencies, lawyers, and courts must be aware and apply these national standards. So the national standards, they came into force, so January 1st. So any court cases that were open or anything that regarded Indigenous children in care was applicable to the national standards. It applies to the federal and provincial governments in how they provide services. It sets out all the standards relating to different care, and again, it has minimal standards. And it doesn't mean the provincial rules don't apply, but it just means where they're in conflict or inconsistent with the Act, then the national standards apply. So if they're not, that section is not in there, the national standards do apply over if the provincial laws haven't met that standard. Where the provincial laws do conflict or are inconsistent, the national standards prevail along with this law. Indigenous laws do not replace these standards. So if Indigenous communities do create their own laws, they do have to meet this standard also. So it's not, they may influence their clauses, but again, they have to also be on that same floor along with everybody else.
So we're going to spend the majority of this presentation talking about the national standards because they're enforced right now. They apply to your practice right now and they should be being followed. And also because a lot of talk around this bill has been on the jurisdiction question, which we are going to speak to as well. But we really want you to have a good understanding of the national standards. And one of the things I think to start about is there's nothing in these national standards that isn't already best practices in social work. I think it can be summed up in 3 words, which are relationship, 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 which is best practice right now, right? So we're going to go through this, and we're going to start with talking about principles. So this act sets out principles that need to be considered when interpreting this act and when applying this act. And there's 3 major ones. Best interest of the child still is the paramount consideration, the paramount principle that is followed in this act. But there is some unique factors, and there's a different approach to best interests of the Indigenous child in this act that is enforced right now. The other 2 principles are cultural continuity and substantive equality. And there's a list that describes these principles. But a couple that just stand out is paying attention to cultural continuity being essential to the well-being of children, family, and communities. And a clause saying that child and family services delivery must not contribute to assimilation or cultural destruction. So paying attention to that, you might say, how is that possible? And we'll talk about this a little bit later. Obviously, that involves discussion with who are the experts in this. The experts in this are going to be the communities, are going to be the Indigenous governing bodies, are going to be the Indigenous families that can help you understand this if this isn't something in your practice right now. The other principle is substantive equality. And so this section says the child, the child's family, and the child's governing body must all be able to exercise their rights under this act. And as well, a jurisdictional dispute must not result in a gap in services. And this is, if people are familiar with Jordan's principle, this is really Jordan's principle now put into this act, saying you can't have a conflict between different departments or between the provincial and federal government where people are fighting over who should be funding or delivering a service. It's point of first contact for the child's needs being met. And then you can argue later. Okay, so let's talk about best interest of the Indigenous child, because there is a different approach. This is really important because the status quo, this act has changed the status quo, and we need to pay attention to approaching best interest of the child in a different way. So this act has a primary consideration clause saying that when best interest of the child is considered, primary consideration must be given to the child's physical, emotional, and psychological safety, security, and well-being. This is a very typical description of best interest of the child. It goes on to say, as well as to the importance for that child of having an ongoing relationship with their family and the Indigenous group, community, or people to which he or she belongs, and of preserving the child's connection to their culture. So what you can see is that in the definition of best interests itself, there is a primacy given here saying paying attention to this aspect of emotional and psychological safety, security, and well-being, those relationships and that connection. So we won't go through all these factors. They set out factors for best interests. And I think what's important to highlight here is that what you'll see is that, like in every provincial statute, you have flexibility, you have a responsiveness to the actual circumstances of each child. So I just want to highlight ones that stand out that seem above and beyond what I've seen in provincial statutes. So one of the things that is a bit above and beyond is C, where it talks about the nature and strengths of the child's relationship with parents, care providers, and any member of their family. So this goes broader, rather than kind of staying in this Eurocentric view of the family, where the only people that are considered might be mom, dad, and siblings, it goes broader than that and recognizes that for many Indigenous children, there are other family members and relatives that have important places and relationships with that child, and that those relationships need to be considered as well. The other piece that I haven't seen in any provincial act is talking about the importance of the child's ongoing relationships with their Indigenous family, community, language, and territory. So every time, anytime I've sat and listened to elders talk about what Indigenous children need, the land comes up, the territory comes up, and now we have this in this act, recognizing that there's a relationship there that needs to be considered. Finally, again, we have the child's views and preferences, recognizing, paying attention to family violence, any other proceedings. But another unique factor here is taking into account any plans for the child's care, including care in accordance with the customs and traditions of the Indigenous group. So this creates an ask. How are you going to find out if there's any plans for the child's care? You need to ask the Indigenous group if there's plans. You need to ask the family, right? That's getting that information so you can actually consider this factor.
So the effect, not just the intent of providing the child and family service, again, it must take into the child's needs, their physical, emotional, psychological, safety, security, and well-being. And it must take into account the child's culture, whether it's First Nations, whether within First Nations it's Cree, it's Dene, it's Blackfoot, recognizing those differences in those First Nations cultures, whether they're Métis, whether they're Inuit, and how do we find out what their culture is and how do we support that? Allow a child to know their family origins, to know where they came from, to know where their family came from, what is the origin of their family. And promoting substantive equality between the child and other children, whether that's children in the home, other children in care, whether it's their siblings. But really important about that substantive equality.
So the other parts of the national standards is we have prevention provisions, we have placement provisions, and then we have post-placement provisions. That's sort of a breakdown for that. So they have preventative care and prenatal care provisions here that are important to pay attention to. All of these, I'll say, because I don't want to repeat it in every slide, will be when consistent with the best interests of the child. So you always have the best interests of the child first and foremost, but keeping in mind it's the best interests of the child as defined by this act. You still need to do that expanded analysis. So there's a priority given to preventative care and prenatal care in this act. It's important to give priority to preventative care measures over other services wherever possible, wherever it's safe to do so. And it's also important to give priority to prenatal care. And this is a provision that talks about prenatal care when likely to be in the best interest of the child after birth in order to prevent apprehension. So this is really important because often, not always, but often in provincial acts, there's a perception by some social workers that there is no jurisdiction to even do planning or support for a family until that child is actually born. It's at that point when the act kicks in. So this provision explicitly says this jurisdiction expands for the sake of prevention, to be able to say if you have an expecting parent and there are concerns or things that are raised, there is jurisdiction here now to provide preventative measures to set this little family up for success. So we actually have a booklet coming out where we've been working with a doctor from the Indigenous Wellness Clinic here in Edmonton on this. But there's three ways of looking at this. First of all, there's preventative prenatal services. And some of those are just essential prenatal services that need to be available for any expecting parent. And there are specialized preventative prenatal services that might be really useful in various specialized situations. For example, family violence, for example, substance use or abuse, being able to address that when it arises rather than having to wait until birth. There's also that preventative services planning for after birth, where it seems likely that there may need to be support after the birth. That planning can happen before birth, so things are set up. Finally, we all know that there are some parents that are not able to safely care for their own children, and sometimes those parents even know that themselves. So it's possible to do some placement planning for after birth before birth, even having a backup plan set up, and we'll talk about the placement priorities here, but having something set up ahead of time. The whole idea here is to avoid that traumatic apprehension at birth where things are happening without that planning and without those preventative services, which is what we all really want. We want the babies to be safe, right?
So one of the other things that they talk about in preventative measures is the socioeconomic conditions in Section 15. And I know it seems like this doesn't happen, but unfortunately it does happen in Canada. A child must not be apprehended based on their socioeconomic conditions, based on poverty and inadequate housing structure. And that goes in, and it's unless, again, it's keeping in mind there's still that best interest of the child that is always there. It's like our conscience, this is what we follow. And then the other part is before apprehending a child who resides with a parent or a family member, the service provider must demonstrate that he or she has made reasonable efforts to have the child continue to reside with them. So if we look at both of those, I would encourage documentation on these, because on the flip side, legal counsel will be coming in and asking you for that documentation on what reasonable efforts did you make, what did you do to ensure that they stayed in those homes. And it could be, this is where we have to start thinking outside the box. What kind of things work in other communities? What kind of wraparound supports do we need to put in that home? Instead of removing the child, do we need to bring in services into that home? Is it best interest to remove 5 children from a home and separate them, or is it the best interest to figure out how we can make that home work with those parents, and what can we do to support them? Is it if it's they need beds, buy beds. If they need some extra tutoring or they need counseling, provide that. So we can provide services that are outside of the box just to ensure that we're making these efforts to keep these children in these homes. And so if we talk to our colleagues, if we do a little research, we're hoping to learn what are these best practices to keep these children in these homes. So hopefully in the next couple of months, Wahkohtowin Lodge will be able to document some of that and be able to provide you with some ideas of how some communities are making these things work and decreasing the amount of apprehension in their communities. And again, still best interest of the child. So, and notice and representation requirements. So now notice must be given to the child's parents or care provider, as well as the Indigenous governing body. Now, some of this happens already in certain provinces based on their legislation, but now this means First Nations, Métis, and Inuit, Indigenous governing bodies, must have notice before any significant measure is taken with the child. And we'll get into those specific definitions because this is where the legal people have lots of fun and interpretation. But now there's more notice required. Some parties have the right to make representation in civil proceedings. So these Indigenous governing bodies can come and make representations at the court proceedings, or parents, or anybody that has party status. So in order to make those representations, they must be given notice.
Okay, so let's talk about some of the definitions. Corinne's right. We legal people will spend a day or a week or sometimes a year on a single word. So we do love words. But the Act talks about Indigenous governing bodies, and they have a definition within the Act. They talk about it being a council, a government, or other entity that is authorized to act on behalf of an Indigenous community that is a rights-holding group that holds Aboriginal or treaty rights. So what does this include? the federal government sets this out. It definitely includes band councils. That's easy. We know that. But it can include other current governing organizations, like Corin talked about. It may be a Métis governing body. It may be an Inuit government that this will apply to. It may be a non-status government that this applies to. And it may become something, as there's so many Indigenous groups in the process.
Oh, we are still frozen right there.
We're back. We're back to this one.
All right. Hear the sound.
Okay.
Yes.
Okay.
Yeah. Perfect.
Okay, so...
Okay, sounds good.
So where did we leave off?
We were at slide 22.
Okay. Okay, so we froze a little bit.
Sorry about that.
So Natalie's just going to go over this in a couple seconds, and then we will go back.
It's me, not you. It's inevitable with computers. It's going to happen. So this is where we stopped when we were talking about that ongoing reassessment for family unity. If a child is placed not with family or in their own community, you need to have a regular assessment as part of their care plan. And this is one clause that is not subject to best interests of the child. This is mandatory. It's a must. So you want to have that part of the child's care plan to be doing regular reassessments. And the other thing is promoting the child's attachment and emotional ties to their family, to their own community, and finding ways to do that safely and creatively. So those are being maintained rather than being completely severed if they are moved out. That can be a cultural connection plan. That can be an access order to a healthy relative. That can be, you can get really creative with that.
So these are the top 5 strategies. We're going to let you review those on your own. When we were frozen, we did a really great explanation of them. But really just focus on educating others because nobody is aware of this law. Like you have a handout that we created. Carry that around with you. Carry the law around with you and share with others. Because really the more people that know, then the more bigger difference we can make in Canada and the better effect we can have. So just moving quickly on to authority. So under this law, it gives Indigenous governing bodies the authority to draft their own CFS laws. Just a note, before this, Indigenous governing bodies, so first, like for example, band councils, could create their own bylaws with the approval of the minister or without the approval of the minister. But now this specifically kind of gives it more power in terms of they can draft their own laws, they can administer and enforce these own laws, and they can provide dispute resolution mechanisms. So that could even be things like maybe they're moving out of the courthouse that we see, and maybe things are done, all children matters must be held in the roundhouse or the longhouse or in their own system. And so that really gives opportunity to be really look at those Indigenous communities and how they want to enact their laws and carry them out. And so it's really a great opportunity to revive those Indigenous laws. So if an Indigenous governing body creates their own law, it will have the same force as a federal law. So again, if they wanted to create their own law, they would, as of January 1st, would give Canada notice, say we are going to be implementing our own laws, and they would have to go through a process. For example, there was a First Nation in Saskatchewan that did give notice to Canada, stating that they were working on their own laws. And again, it'll prevail over other federal laws, except, of course, the Canadian human rights and the Charter, and it'll prevail over all provincial laws. But again, it must still meet those national standards. Those don't go away. It still must meet them.
And there's limits to this jurisdiction because courts have said governments are allowed to limit this jurisdiction. So there's limits within this act. So Indigenous Child and Family Services law are subject to the Charter and the Canadian Human Rights Act. There's a clause talking about what happens when a child belongs to 2 Indigenous groups, and it's a Stronger Ties Act. That's going to have to be sorted out, but to the group where the child has the stronger ties, theirs is the act that will apply. And finally, the Indigenous Child and Family Services law will not be applied if they are deemed contrary to the best interests of the child. Again, as defined within this act, as approached within this act. So that is always in place. So there are these limits to be paying attention to. It's not a complete divorce, I guess.
So again, there's best interest of the child on this shoulder, and the national standards on this shoulder always have to be kept in mind. So in order for these laws to be recognized, again, there is steps. So one, they have to give notice to the provincial and federal government of their intent. They have to enter into these coordination agreements. We have not seen what these coordination agreements look like. We are eager to learn what they look like with the province and feds. There is the possibility that if they give notice and they try to make these coordination agreements within a year, and say, for example, the province that they're in doesn't respond, that doesn't mean that they can't move forward. They can move forward. So it's in the best interest of all parties to respond. But again, maybe some provinces might not respond. It has to show that they've made reasonable efforts. So again, they must document and show what they've done in order to make these reasonable efforts. Who have they talked to? Who have they given notice? What provinces they talked to? And then again, they must make public and publish these documents. So if you're looking for documents, there will be probably somewhere on the Indigenous Services website, there'll be a drop down somewhere in there where you can go and see who has made laws under this legislation, and you will be able to access to those laws. So it saves everybody a lot of time, and it just centralizes them, which makes it a lot easier for us to carry out the work that we do.
And so what about funding? This is a big issue. There's only one clause that addresses funding, although we do have the principles of substantive equality, which also talk about that. There's one clause that says governments may enter into these coordination agreements, which nobody does know what they're going to look like right now, which may include fiscal arrangements that are supposed to be sustainable, needs-based, and consistent with the principle of substantive equality. Again, the goal being long-term positive outcomes for Indigenous children, families, and communities. So top 5 strategies, what does it mean? One of the things I think to think about with jurisdiction is anything new, sometimes people feel afraid of, but it's exciting. There's lots of possibility here to learn new and better ways of meeting the needs of children and families, which is what everybody enters this field in order to do. So really important to be consulting and listening now. You don't need to wait until you're consulting a draft piece of legislation or an enacted legislation on a website. Start building those relationships now to be finding out what Indigenous governing bodies and communities think are wise ways of meeting Indigenous children's needs. Seek out the experts. Of course, Indigenous communities are the experts on their own laws. So doing that relationship building, asking clarifying questions are going to help you understand that. That's, again, the working together, seeking out resources to deepen your understanding. If there's things that you don't understand, there's lots of great research and work out there already that you can start educating yourself on Indigenous children's and families' experiences, but also Indigenous laws, Indigenous governments, to have that understanding so you're approaching things in a more open and full way to make the most of this.
So some important steps for you to do. One is to really look at what your organization is doing. Are you currently already meeting those national standards? We've talked to some agencies and they're already doing this. And so they're just compiling it, putting it together, creating your own checklists for your workers, social workers when they go to court, creating new ways to document things in people's files. So it's really just looking at our practice and updating it, or how do we show what we're doing already? And how can we create those checklists? And if you're a non-Indigenous organization and you work with a designated First Nation who has their own agency, and this is an opportunity to create that relationship, because when you have to go through those placement priority steps, you have to go out and do that work. And so who's best to show you and support you in that is those Indigenous organizations. And so really building that relationship so that you can go out and do this work. And so it's really important to get out there.
Other important steps. What do you need to learn more about? What are you curious about? What don't you understand? What do you need to seek out knowledge about? But also thinking about what do we all need to unlearn? Murray Sinclair talks about, Senator Murray Sinclair, who is the head of the Truth and Reconciliation Commission, reminds us that as Indigenous children, we're taught in the residential schools that everything within Indigenous communities and governments and laws were bad or useless or didn't exist. Non-Indigenous children were being taught the same thing in non-Indigenous schools. So we all have unlearning to do. We all need to be questioning our biases or the things that were taught to us as common sense when we were children, or that we see in the news that are affecting our practice and are affecting our ability to listen and understand what's going on. So thinking about what are your first steps internally and externally, and what are your long-term hopes and goals? If you picture the best case scenario here, what does that look like? What would you like to be doing to be contributing to the well-being of Indigenous children, families, and communities? And then, of course, backing up and asking what's a realistic timeline and what resources are required. So we'll leave it at this. We're encouraging people to understand this act and comply. It is the law. The national standards are the law. So compliance is where we started. But let us end. This is a quote by Sidney Hill, where he says, "Let us put our minds together and see what life we can make for our children." And I really hope we can leave you with the idea that Bill C-92 is about hope and it's about connections. We know this, that having those connections and those relationships on all levels is what leads to the best outcomes. And that's the practice where we feel hopeful and that like we're actually contributing and doing what we set out to do when we began our practice. So we just want to leave you with that there's so much opportunity and hope and exciting, creative things that you can be doing in your practice to meet the national standards and go above and beyond.
Amazing.
So this is our contact information. We have some more resources. We saw some little pictures of some resources that we're creating. Continue to check back. We have a Facebook page you can join us on, and we just talk more about what Wahkohtowin is doing. You can follow us on Twitter. So yeah, and then if you need to contact us for further information.
Amazing. Thank you so much. We have a ton of questions, as I'm sure you can imagine, which is good. We'll try and dive into some of these. One thing I will note is we may go just a tad over the 1 p.m. to make up for the little bit of a freeze. So just a heads up that if you have to hang up now, it will be an online on-demand version for you to check in with as well. So feel free to type your questions as we go, but I'll get started with some of the ones that were asked during the presentation. One of them is wondering about if this came on a little bit earlier. Does the bill compel health systems to be more responsive to the needs of young moms who might need more support with prenatal care? Does the legislation compel that?
I think there's a good argument to be made. So that's probably a frustrating question to hear, but it's a real legal answer to a question about that. I think there's a good argument to be made that it does, because the bill does talk about that these are principles and practices in the context of child and family services delivery. But we know we also have the substantive equality clause saying that jurisdictional disputes shouldn't prevent this. And we know that not all jurisdictional disputes are just between federal and provincial governments. They can be between governmental departments. So I think there's a good case to be made, and I think health systems need to be being pushed to provide these prenatal services and to work in a coordinated way.
Amazing. Yeah. That's a fantastic answer. It's very interesting to see. There was some summits happening in Ottawa last week about some prenatal care in terms of from midwives, and hopefully a resurgence of Indigenous midwife programs across Canada. So fingers crossed with that. Another really good question. We got a lot of questions about funding. So some people wondering about if you can provide a little bit of insight on the funding of this.
So that section that we showed you in the slide is basically the section from the legislation that talks about funding. So we've been hearing different things across Canada about funding, and there's some positive and then some negative regarding funding, but there's no funding provision. So it's really up to the Indigenous governing bodies to advocate for funding if they want to create their own laws, and then for Indigenous organizations about how you plan to carry this out for Indigenous, like child welfare organizations or non-Indigenous, to really talk to their governing bodies, their boards, and their provinces about the funding that they get and how to sort of think outside the box and continue with the current funding. But again, it's really a lot of unknowns in that. But I think as we move forward, especially as people are moving into the next fiscal year, we'll be able to hopefully see a lot more and have a little bit more answers for you. So if you follow us on Wahkohtowin, as we find out information, we'll be sharing that with you.
And I'll add something about the national standards, because sometimes this comes up, right? Is if you're working as a provincial social worker, and you can see that buying beds is the solution to a family, to keep a family together, etc. Who should fund that? And if there's any supervisors or people who can make these decisions listening, what I would advise is do it. Do the gold standard. Meet these standards. Follow this, and then I think, again, thinking about Jordan's principle, provide the service, and if you want to fight with the federal government about funding this service, fight with them afterwards. But I think it's a better fight and a more productive fight than the fight, let's say, like Quebec's reference right now, challenging the constitutionality. I think hold the feds' feet to the fire, and ask them to back up these national standards with funding, but provide the service first.
That's great. I think that there's one that just kept coming up and up and up is about the assessments, and if you believe the assessments are meeting the credentials or how you would like it to be done in terms of assessing best interest of the child. Can you just touch a little bit more on that?
I think if one of the easiest ways is, and that assessment is overwhelming because it's like, do we reassess all of our files? And then we've had some DFAs, do we reassess all of our off-reserve files? And you don't have to bite that big, but we do have to start taking a small bit every single day. Okay, let's look at our high risk. Maybe we need to just reassess this and look at the situation. It's an opportunity for some of the private ones to reassess, and if they're not responding to any cultural plans, well, let's call them on that and ensure that the best interest of the child regarding their culture is re-implemented into that home. And so really looking at how can we do this, because the opportunity is also going to come for parents to request the reassessment, and an opportunity for children themselves to request, possibly through a child advocate, their own reassessment. Is there an opportunity for reunification? Have people's lives changed? And so it's really just looking at that again, but you'd be looking at it one step at a time, and it can be overwhelming if you look at it as reassessing everything. But again, it's just reassess, like, really what's in the best interest of the child, because so many times it's case closed and it's put on the shelf, but that's not the case anymore.
Great. Okay, I think we have time for maybe one more. I don't want to keep our presenters too much longer. This one's about the dispute resolution. So we had one of the attendees, a couple actually, talk about how the early drafts of the bill, questioned the accountability of the dispute resolution mechanisms. Do you feel that these jurisdictions of resolution methods meet your expectations? What is your experience in terms of the dispute resolution coming out of this bill?
So is this in referral to the jurisdiction,
Yes.
the jurisdiction to create dispute resolution services?
Yes.
So, I mean, it's vague, right? There's a lot in this act that's quite vague. And certainly myself and Naomi Metallic, who's one of our colleagues, we testified at the Senate, we testified at the House of Commons and said, please be a little less vague and get a little more specific so we have some certainty. And they listened to us on some stuff, but not that. I think the possibility is there. Dispute resolution mechanisms can be created, but what those end up looking like and what's the accountability is the question. What was really pushed for, sometimes people really focus on that jurisdiction and say, well, a dispute resolution process created by an Indigenous governing body. What's that going to look like? What's the accountability? But that has not been the biggest issue with accountability for provision of child and family services for Indigenous children and family. The biggest issue of accountability, and you have 15 years into the Caring Society case to attest to this, has been the federal government, has been government's accountability. So I don't think this bill went far enough to create some oversight body and some dispute resolution mechanism to really hold provincial accountable to service delivery. I think it definitely could have gone further.
Yeah. Yeah, amazing. Okay, sorry, just one last more. We got a lot about determining the best interest of the child, best interest in quotations. Can you provide insight on who decides the best interests of the child?
Everyone.
Yeah. The more people at the table, the better. Like I would say that the number one problem that you can track back to the early 1950s is that and you see it in Brown in Canada, where Indigenous communities were supposed to be being consulted and weren't, and there was this insulting submission by Canada saying, well, nothing would have changed. Who is in the best position to identify the best interests of the child, the best interest of an Indigenous child? I think it makes intuitive sense that that's going to be Indigenous families and communities. Everybody has a role here. Everybody will have a story where you can talk about an exception one way or the other, but overall, overwhelmingly in Canada, we have not had that where I would say document what the Indigenous family and the Indigenous governing body says they believe is in the best interest of the child. And you need to do that self-reflexive practice. If you disagree, why? Where is that coming from? What can you incorporate? What might you need to learn more about? But if you don't know, if you can't write down and document what the Indigenous family and Indigenous governing is saying is in the best interest of the child, you haven't gone far enough in that analysis.
And it's really getting us out of that idea of working in this vacuum. And it's really opening up our doors and getting more people at that table to discuss who's in that best interest of the child, getting the grandpas and the aunties and the uncles and getting more people involved. So our tables are going to have to get bigger, and we're going to have to open up those doors, and we're going to have to go to those communities to learn more about what is in the best interest of the Indigenous child. And that's a really key point in this bill, is it's the best interest of the Indigenous child.
Yeah, and rightfully so. I think our tables need to get longer. That's for sure, when discussing what we're going to need to do going forward to assess everything we've done and everywhere we need to go. So with that, I'm so sorry if we didn't get to your question. We did have a lot of them, and we got a ton of thank yous for this incredible presentation. This has really been taken to heart, and so thank you to our webinar presenters. Please get in touch with them. Please follow their work. You know, if you do have questions, they aren't going to be just disappearing after this webinar is over. You can stay up to date with what they're doing, the important work, and hopefully connect with them or connect with us here at the CISW as well. So on that note, I think we're going to wrap up. We do have some people wondering about maybe using your slides and working with their organizations, a lot of group viewings, a lot of 15 people in a room, child protection. So what do you say about that? Is there? Well,
the slides, they're there for you to use for your organization. Obviously proper reference. And then again, we have a lot of resources on our website that there's more than just what we've been published and what we've talked about that are there for you. And at the end of the day, it's for what's the best interest of these Indigenous children and how can we make a greater impact on Canada.
Yeah. Amazing.
And we'd love to hear from you. We'd love to hear your questions. But as Corin said, we'd love to hear your best practices and your successes and your ideas. We'd love to hear from you as well. So feel free to be in touch.
Amazing. With that, we're going to end the webcast today. Thank you so much, everyone. Please be in touch with us, be in touch with our presenters, and let's get out there and make sure that this legislation really changes some lives in some communities. Thank you so much for joining in. We'll see you next time.
That's cute. That was good. Wait.